So on behalf of the Center for the Political Future here at USC Dornsife, welcome to today's program, whether you are with us in person, on Zoom, Facebook Live, or YouTube. What a world we live in. Or whether you will hear this event on our podcast, Let's Find Common Ground. Our topic, the courts and the future of democracy, is fascinating and complicated, and it is important, in my view, and even fundamental as an issue right now. Let me introduce our panelists. Jeffrey Toobin is an opinion writer for the New York Times. Early on in his career, he was associate counsel for the independent counsel investigating the Iran-Contra affair. He's a best-selling author of a number of books, several of which focus on the Supreme Court, and he is, as most of you know, a regular on CNN. Franita Tolson is the dean of the University of Southern California's Gould School of Law. Alexander Sasha Volokh is professor of law at Emory University and a former law clerk for both Sandra Day O'Connor and Justice Samuel Alito. Quite a combination. Our fourth panelist, Skye Perryman, sadly tripped and broke her ankle last night after she arrived in LA, and she's unable to join us. We send her our best wishes for a speedy recovery. I'll converse with the panel and then make sure to leave 15 minutes or so for audience questions at the end. And I'm going to begin with a question I hadn't, when I initially put this together, thought I would be asking, but we'll just go straight down. What do you think of the James Comey indictment? What it says about the state of law in this country and whether it's likely to succeed?
Should I start?
Hello, everyone. This is so great. I love it here. I like USC. You know, I owe much of my journalistic career to a Trojan, but that's enough about OJ. But it's true. I spent 2 years here covering that case. Anyway, we'll move on. The Comey case. One of the amazing things about the Comey case is to look at the indictment itself. It looks like it was written by a first-year law student who had sort of heard what an indictment is but didn't really understand what it is. You know, the whole purpose of an indictment is to inform the defendant and the world of the nature and specificity of the charges against him. You can't even tell what Jim Comey is charged with by reading this indictment, and there's a very active debate among those of us who follow the case about what the false statement actually is. And I think that's indicative of what an unbelievably shabby process it was that led to this indictment. I would be willing to bet at this point that this case will never go to trial. I think there are so many grounds in which to challenge it, including malicious, vindictive prosecution, and just the defects in the charging instrument itself. But what it signals about how the Justice Department is operating now, as I'm sure many of you know, the career prosecutors, even the Trump-designated U.S. attorney, refused to issue this indictment because they thought it wasn't supported by the evidence. And I think as we see more high-profile targets, whether it's Adam Schiff or Tish James, the Attorney General of New York, that this prosecution of political enemies will be a defining feature of this administration. But I think this case is so defective that it will actually never happen.
Franita?
Actually don't have much to add beyond that. I think it's probably more important to think about the Comey case as what it signals about where we are as a constitutional order. So there are a couple risks here. I don't think anyone believes that he'll actually be convicted of anything, as Jeffrey pointed out. But I do think that part of the goal in bringing charges against him is not that he'll be convicted, but what it signals about the president's absolute authority over the Department of Justice. And But one thing I would caution people against, and we saw this kind of in the wake of the 2020 elections, right? We tell the story about how the courts held, right? All of these election challenges to the 2020 election, the courts held. When the indictment against Comey is dismissed, or when this goes away, I hope that people don't take that as a false sense that the courts are working. And I know that we will get to this. But it to me, it also runs the risk of creating this false sense of security that the courts are well equipped to save us from everything that we're going on now. And this can become another data point for that. And so I would just caution against that, right? In some ways, the indictment is so poorly written that it should be thrown out. But I also want to say that that doesn't necessarily mean that the courts are the ones who are kind of in the front line, that we should rely on them to save us for all of that. And I know we'll get to that, but I think that's an important point.
I too don't think I have anything that original to add to Jeff's great analysis, and Franita's also great analysis. But I think that what we're seeing is just it's typical of what's coming out of the Trump administration these days. Is you have things which are shabbily written, and rather than reading as serious documents that are aimed at a court, they read more like press releases that are aimed at the MAGA movement, and they say more about the president's testing whether he really does have absolute power over the executive branch, and in addition to the interiorum effect on the regulated community. And so responding on Franita's last point, I think that this is a case where it looks like the courts are working because we don't expect that it's going to get to trial. But at the same time, I think Franita is right that there's so much dumpster fire stuff coming out of the administration, and much of it the courts are not really well positioned to save us from. I think the courts have a limited role to play in saving us from certain things, but I mean the rest, we shouldn't be complacent about this, and just ordinary politics has a role to play.
If I can just add one more point about the Comey family. The Trump administration is operating according to the North Korean principle that the entire family has to be punished for the misdeeds of one person. And Maureen Comey, a very distinguished assistant U.S. attorney in the Southern District of New York, has been fired, and she is challenging that in court. And I think in many respects that case is more legally significant than her father's case is, because the legal principles about whether any federal and government employee can be fired for any reason is what's at stake in that case. And I would just urge you to keep an eye on the Maureen Comey case as well as the Jim Comey case.
And I think part of the point here is to make him spend a lot of money and go through a lot of Hazarai, knowing that almost certainly you're not going to get a jury in the Northern District of Virginia that's going to convict him. But this leads me to the first question I was going to ask, which is that critics allege that the American system of checks and balances, the guardrails of our democracy, are under threat today. What is the proper role of the courts and the Supreme Court in safeguarding our system? And Franita, you mentioned this, so why don't you start?
I think it depends, right? We get so used to this idea, and we've been conditioned to think this way, that the courts are supposed to kind of be our bulwark against anything going wrong with our democracy. I would actually challenge that, because I am a historian who studies Reconstruction era voting rights, right? So my experience with the courts in American democracy is quite different from, I think, most people's experiences, because I've seen the courts do absolutely terrible things just in the course of my research. And our tendency today is to look at this court and compare them to the Warren Court, right? So the Warren Court, the Brown versus Board of Education Court, the court that found that the 14th Amendment actually protects an affirmative right to vote. That was the Warren Court. And we look at that as like the standard, but the reality is that the Warren Court was really an exception in our constitutional tradition and order, as opposed to the rule. And I would even go as far as to say that the court that we're seeing now, yes, this feels unprecedented in our lifetime, but in reality, I think it's more in line with the Supreme Court for most of its 200 plus year history than the Warren Court, right? So in part, we have to I guess, adjust our baseline for how we think about what the court is supposed to do based on what the court has done. And the reality is that for most of its history, the court has not been very protective of democracy. And the Warren Court was just this really exceptional period where you saw the court take a pro-democracy stance.
Sasha, how do you react to that?
Well, I think when people look at the Trump era Supreme Court, there are a lot of separate phenomena that get bundled together. One is just that because of the changes in personnel on the court, we're living through a period of rapid constitutional change. And we've seen this before when the median voter on the court changes, and in 1937 and in 1968 and in 1991, like those are periods when, because the median voter is different, then the majority of the court is interested in different sorts of rulings. And then you see rapid change in a lot of doctrines, like, for example, abortion and affirmative action, and now with Humphrey's executor and so on. And that is, I'm going to say that's normal. That is, there's a lot of very Trump-specific stuff that's coming out of the Trump administration and is related to Trump's own authoritarian tendencies and so on. But I think that a lot of what we're seeing is just the normal change in constitutional doctrine, because there are many of the longtime goals of the conservative legal movement which have existed for several decades, and now many of them are being fulfilled. Well, that's one thing. The other thing is that the Trump administration is really one unprecedented thing they're doing is they're bringing all of these cases to the Supreme Court on the emergency docket. And there are all of these decisions that are being issued with really no reasoning, and we don't know what they're thinking. And to the extent they have to apply equitable factors on whether to apply a stay, it's often very inscrutable what they're thinking, or they seem to be kind of bending over backwards to not apply them in the proper way. And I think that is problematic. But the third, and this is, I think, a big thing, is if we just focus on the high-profile cases that make it to the Supreme Court, that's not the full story. And I think one of the best writers on this is Steve Vladek, who is a big expert on the federal judiciary. And he has pointed out in a recent post that the Trump administration, a lot of their cases they're going to lose. And they know they're going to lose them. And they are losing them in the lower courts, and they're taking that loss and are just continuing to go very slowly through the federal courts. And they are bringing to the Supreme Court on the emergency docket just those cases that they think they're likely to win. And so if you see that they have a good win ratio at the Supreme Court, you risk ignoring the much larger mass of cases that are very slowly going through the federal court, the lower federal courts, where probably the administration is pretty sure they're going to lose, but they just don't want to lose quickly.
I share your admiration for Steve Vladek. I think that is bullshit. I think they want to win all these cases, and some they're pushing faster than others. But 1981, Ronald Reagan wins the election, and Antonin Scalia at the University of Chicago and Robert Bork at Yale Law School, they are the first faculty advisors to the Federalist Society, and they recognize that if you want to change this country, you have to change the federal judiciary. And they have been focused on this project for decades, and Democrats have not paid the same attention to the courts. I interviewed a bunch of presidential candidates, Democrats who, said, "Oh, I just want to appoint the best judges, and excellence and diversity is what I care about." And when Donald Trump ran for president, he said, "I am going to appoint justices to the Supreme Court who will vote to overturn Roe versus Wade." And what I think he meant by that was, he was going to appoint justices to the Supreme Court who were going to vote to overturn Roe v. Wade. And that's what he said he was going to do, and that's what he did. And this has been a political project of the Republican Party for decades. Mitch McConnell saved 3 seats on the Supreme Court for Donald Trump. He stymied Merrick Garland for a year when Obama appointed him. He got Brett Kavanaugh through, despite very credible, serious allegations against him, and then he rushed Amy Barrett through after Ruth Bader Ginsburg died. That's because it was so important to the conservative movement in this country to capture the Supreme Court, and we are now seeing the consequences of it.
I got to say that I think Democrats, when they were supporting particular nominees for the U.S. Supreme Court, I think the idea that we want someone who will retain Roe v. Wade, that was an important litmus test.
But they wouldn't even say that. The judges wouldn't even say. They'd say, "Well, I want judges who will respect precedent." You know, wink, wink. We know which precedent they're talking about. They backed away from the political content of the Supreme Court. Just, you know, in 2016, when Hillary Clinton was the Democratic nominee, and Merrick Garland was being held hostage that summer, neither Hillary Clinton nor Barack Obama, who was president at the time, mentioned the Supreme Court at the Democratic convention. I think that is indicative of how this was never viewed as really a central issue. I just think, you know, I'm not sure history would be any different, but I think at least what we recognize now is how important the Supreme Court is to how we live as Americans.
Yeah, I want to get into this a little more, the situation between the federal courts and the Supreme Court. I do have to add that there was one president who said he was going to appoint somebody to overturn Roe v. Wade.
And I know who you're going to say.
And it's Ronald Reagan. And when it came time to appoint a justice to the court, Sandra Day O'Connor, he said, we can't ask her how she's going to rule on specific cases. I believe he may have understood how she was likely to rule in that case and decided that with his reelection coming up in 2 years, he was not going to put someone on the court who would vote to overturn Roe v. Wade. So I think that there's a certain political aspect to this. I don't think Donald Trump cared about this issue, except that it was important to his base constituency. Can we talk a little more, and maybe we'll start with Franita again. The federal courts have not only overturned a number of the president's decisions on issues ranging from immigration to birthright citizenship to the cutoff of federal funds for Harvard, but they've also issued nationwide injunctions against those decisions. The Supreme Court, often without explanation, then used its shadow docket to overturn those lower court rulings. How do you assess the apparent tension between the lower federal courts, which claim they are applying precedent in making these decisions, and the Supreme Court, which is overturning them?
I don't know if I would describe it as tension, right? It's kind of like when you are the boss and then like your employees feel like they have tension, but they really don't because you can fire them. That type of, like, it's not really tension, right? The Supreme Court feels like, I mean, we're saying that they feel like they can do whatever they want to do, right? This actually goes back to the last conversation too, because I think there's a difference between thinking about the court institutionally, right, which is what that last conversation was, right? Appointing justices of a certain ideological bent because you want the institution to operate in a particular way, but still within the constraints of the institution, right? Still within the constraints of the rule of law, still within the constraints of precedent, versus the court being a tool of the administration, right? I think it's that we're not used to, and that is potentially what is going on here, right? So when we say that there's a Republican majority in the three branches of government, we are actively describing the court as a tool of the administration in a way that I think most people alive today did not see it. And I'm not even entirely convinced that, you know, earlier presidents, Reagan and others who were thinking about the conservative legal movement were thinking about appointing justices with the intent of making the court a tool of the administration, right? So I think that that's a separate question. So if the Supreme Court is a tool of the administration, then really there's no tension, right? Because the Supreme Court is the one that sets sort of the pace of what the lower courts are supposed to follow. Whereas the lower courts, in some ways, they are acting pursuant to what the world used to be, and the Supreme Court is correcting them. Now, I know that makes everybody or some people uncomfortable, but I do think that we're living in a world where it's probably more accurate to paint the Supreme Court as the third Republican-led branch of government.
I just would like to do something that seems to be illegal these days, which is say something nice about Joe Biden and Chuck Schumer. Joe Biden and Chuck Schumer and Richard Durbin, who was chairman of the Judiciary Committee, pushed through 254 judges while during the Biden presidency. They finally recognized how important, and I guess, Franita, I disagree a little bit. I think these lower court judges do matter a lot. Now, well, I know you didn't say they didn't matter, but I think they have a lot of influence in how these cases come out because they can't appeal every single case. And I view these judges as political actors. And if you look at which president appointed which judge, you can tell how these cases are going to come out if that's the only thing you know about them. And I think, the hydraulic pressure you're talking about definitely exists. But, these lower court judges, as as Bob pointed out, there have been a lot of cases where they've had an impact and they haven't all been overturned.
So I will say that, so I don't disagree with that actually, but I think it's just by virtue of the fact that the Supreme Court only grants certain like 75 cases a year, right? So they can't overturn them all.
So,
Yeah, so I guess
Sasha,
I
let me
was
try
gonna
a
say
follow.
yeah.
Let me try a follow up
sure.
here. The three liberals on the court, if I can call them that, have often issued sharp dissents from the rulings on the shadow docket, with only an occasional concurrence from the court's majority, which is largely silent. Justice Amy Coney Barrett has defended the majority's choice to be silent by saying of the emergency docket, and this is an exact quote, "We are in a position where we might be writing sooner than we want to be, or with less information than we want to be. So sometimes less is more. If they have less, how can they decide the case?"
Should we just say for people who are not insiders what the shadow docket, emergency docket is? Why don't you?
Yeah, well, so actually, show of hands. If we say shadow docket or emergency docket, who kind of knows what that means? Well, a good number, not everybody. But yeah, so like, sometimes you have
U.S. v. Nixon was.
you have a case that's decided, let's say, adversely to the administration in a lower court, and the administration could go and appeal it to the Court of Appeals, and then ultimately to the Supreme Court, and that'll take a while. But you have all of these preliminary questions like, should you stay the lower court decision while the appeals are going on? And that can be an important intermediate victory for the administration, and so you can file these emergency motions asking for a stay pending appeal and so on. And generally that goes to one justice, and the one justice can forward it to the entire court. And so you get these decisions on an emergency basis, and often with no reasoning at all, so we don't know exactly what they're thinking. And so, yes, sometimes you've got the liberals who have a sharply worded dissent saying, what exactly are you thinking here? And I am critical of what I think is the overuse of what they might call the emergency docket or the interim docket or the shadow docket or whatever you want to call it. I think the way that judges have legitimacy in our system is... Sorry, the way the judges have legitimacy in our system is because they give reasons. And the way that vertical precedent works in this country is that the lower courts are bound to follow the reasoning of the upper courts. And so, if you have a decision with no reasoning and then lower courts don't really know what to do, but also from the perspective of do we believe that the courts are doing anything more than nakedly political judging? Maybe they are being in good faith, but I can't know that because they're not saying what they're doing. And so if they really don't have enough information to go on, they could always not take the case. Like, there are many cases that are going up on the emergency docket that don't really need to be there. And they can just decide, no, we're going to hear this in the ordinary course. And I think, in a sense, yes, the Trump administration is trying to force the issue, but the Supreme Court does not need to take the bait all the time.
But I think this argues for what Franita was saying earlier, which is this is a court that's doing the Trump administration's bidding. I mean, look, the
Well,
Supreme Court.
but I think that it is. I don't think the Supreme Court is generally doing the Trump administration's bidding. I think the Trump administration, if cases come to the Supreme Court in the ordinary course, birthright citizenship, for example, or maybe tariffs or something, the administration is, or commandeering, the administration is quite possibly going to lose. But I think that, yes, in terms of the shadow docket, I think that, yes, the Supreme Court really leaves itself open to that.
I disagree. I think they are generally doing the Supreme Court, doing the Trump administration's bidding. The Supreme Court's been around a long time. It's only in the past 7 months that the shadow docket has started there have been these decisions that change American life in a profound way that come out in 2 or 3 paragraphs. Humphrey's Executor is a case that law professors have been torturing their students about for since the 1930s. Am I right? Mm-hmm, yes. Mm-hmm. It's a case about whether whether there can be independent agencies like the FTC and the NLRB, where the president can only fire the members for misconduct. And that's what Humphrey's Executor says, is that they have a measure of independence. They can't be fired just because the president doesn't want them in office. Well, this administration hates Humphrey's Executor. He wants to be able to fire all the members of the FTC, all the members of the NLRB, because of this theory called the unitary executive. Humphrey's Executor is a very big deal in the law. It has been overruled in these 2 and 3 paragraph opinions, which is just not the way the court is supposed to work. I mean, if you're going to overturn a major case, at least write an actual opinion saying why it should be done. But because they are doing, the bidding of the Trump administration with such alacrity, they're doing it with these shabby little opinions. And, I just think that discredits the court, even if you believe that the ultimate result is correct.
I just have to observe before I go on to the next question that one of the very interesting things that's emerged from this panel is the notion that I think Sasha may disagree with to some extent, that these folks reflect a political program from the president who appointed them. If you go back to like Eisenhower, I think he was kind of surprised by Earl Warren and Bill Brennan after he appointed them. I already cited Reagan and Sandra Day O'Connor. I could also cite Bush and David Souter, who Souter voted very differently, I think, than Bush might have preferred. So we do have, in my view at least, a court that is very rapidly changing some of the basic constitutional principles. And you have to hope, depending on your perspective, that Sasha's correct, that when it gets to, say, birthright citizenship, which I think is completely clear in the Constitution, and I want to talk about that a little bit later, or tariffs, that somehow or other the court on the merits will say, maybe 5-4, 6-3, you can't do this. But there might be one safeguard that Sasha talked about. The president, pardon me, has issued a fusillade of executive orders. I mean, just one after another. It's like a Gatling gun, which have triggered a massive number of lawsuits. Can the courts possibly keep up, and can the Supreme Court keep up?
Oh, well, I think the Supreme Court gets these things late in the day, which is part of, and sometimes it's a benefit and sometimes it's a cost of our system, is that the wheels of justice turn very slowly. I think the district courts are fully capable of taking care of all of this. People file a ton of lawsuits, and eventually it goes to the appellate courts, and eventually it gets to the Supreme Court, and the Supreme Court is going to take the ones that it thinks are most important. So yes, there is a lot of it. I don't think the courts are ill-suited to take care of it. And I think they've been doing, in general, I think the courts in general have been doing a good job in stopping a bunch of illegal activity from this administration, either from executive orders or from other sources.
Franita?
So why are we talking about the court as if like these aren't people, right? Like I think so. One of the reasons I'm pushing back against this is because we tend to venerate the justices, right? Like they're supposed to, sort of embody this, higher lawmaking. When we say things like, will they be able to handle this? Will they push back? Maybe they agree, right? Like maybe it's probably easier to think about this as the justices using the shadow docket because there are precedents that they don't agree with, and it's an easy way to gut them, right? Like maybe they agree. And that kind of makes us uncomfortable given our constitutional tradition. But then again, we also have to consider the fact that the court creates its own traditions. This whole notion of precedent, that's not in the Constitution. When we talk about methodology, textualism, is a justice an originalist? Are they following that? They decide that. Right. And these are people who make a affirmative decision about who they want to be as a justice and what they want the law to look like. Justice Thomas. Justice Thomas has said repeatedly that he doesn't think that precedent should be honored in constitutional cases. Right. So it's not, I think sometimes we put our own expectations on the court. And that's why it's so difficult to answer the question of what we expect the court to do. So I agree with Sasha. I think that the lower courts can handle all of these cases. They handle thousands of cases all the time. But I do think we need to readjust our assumptions about who the Supreme Court is in order to kind of understand how they are political actors in this, to reference back to something Jeffrey said.
Let me follow up on that. We'll start with Jeff. Why do you think Chief Justice Roberts and the court's majority seem so disinclined to confront the president? Is it because they agree with him, or because they worry about the court's legitimacy and its capacity to enforce its will?
I just would like to, reflect what you just said, which is it's because they agree. I mean, the idea that it's some that what they really want to do is push back, but they're worried about their orders being honored. I mean, Franita is exactly right. This is who they are and what they want to do, and they are not, sitting there. They probably wish that Trump would express himself somewhat differently, that he wouldn't say nutty things on social media. But when it comes to these substantive issues about executive power, about individual rights, about civil rights, about voting rights, they are aligned with President Trump. So I don't think there is some crisis of conscience going on there. Now, these are human beings. They don't agree 100% of the time. I mean, we'll get to this. I think birthright citizenship is probably one case they will lose, that Trump will lose. But other than that, I can't think of any, including the big tariff case, where I think Trump is going to lose in an important case. And that's because that's what that is their political and judicial philosophy, which are essentially the same philosophy.
Sasha?
Well, I think on sometimes yes and sometimes no. That is, we understand that there is a lot of overlap and correlation between certain presidents' political programs and certain justices' constitutional commitments. That is, if you had a highly liberal U.S. president at the time that there was a highly liberal Supreme Court, we would expect that the Supreme Court would uphold a lot of things of the liberal president. And there are a lot of if you have conservative appointees and a conservative president, you expect that a lot of stuff there gets upheld. And it's not because the court sees itself as doing the administration's bidding, but because there's just a lot of overlap between certain jurisprudential commitments and certain political commitments. Now, I think that in the case of Trump, that is much less true than usual. So, for instance, well, like here's my laptop that has all my stickers on it. And it's got FedSoc here because I've been the faculty advisor of my law school's Federalist Society chapter for many years. But I've also got Planned Parenthood here, and I have a gay cat that I picked up at Pride, and so on. But I'm a Democrat, and I've been a Democrat since the day after Trump was elected president. And so, like, I'm the least Democrat of the Democrats, but I'm also the least Republican of the Republicans. But anyway, so let me. It's Donald Trump is just the greatest, recruiter for the Democratic Party. Anyway,
but he hasn't recruited that many.
No, yeah,
that's why they keep losing elections.
I'm sadly not necessarily representative, but what I'm saying is that people might say, well, if you're so anti-Trump, how can you still be aligned with the Republican Party? And the reason is because I think 80% of what's coming out of this administration is a total dumpster fire, but the reason I think it's a dumpster fire is for reasons that are like right in what I feel are core commitments of the Federalist Society. So I feel like there are certain things where the Supreme Court is acting in an ordinary conservative way, which I just think any Republican president, would like that, like overruling Roe v. Wade. I am fairly radically pro-choice, but I think that overturning Roe v. Wade was the right thing to do as a jurisprudential matter, and so I'm happy about that. Though politically, I always vote pro-choice. But then there are other things where there are real fault lines within the conservative movement, and part of what makes Donald Trump, historically significant is that he has totally reworked what being Republican is all about, and being Republican now means aligning oneself with all sorts of things which are kind of the direct opposite of what I thought being Republican was just 10 years ago. And so I think that you have people on the Supreme Court who, yes, some of the time they are going to vote the way Trump likes, but other times they just have commitments that go the other way. And so things that involve some kinds of executive, like federal power, like commandeering, and I think a lot of things the administration is just going to lose because he's going contrary to what are kind of core conservative jurisprudential commitments.
Like where? Where is this Republican division that I sometimes hear about and that I hear about here? I don't see it. I mean, like the six of them vote together all the time. So like, where's this great internal fight in the Republican Party?
Well, because there are certain things like abortion, affirmative action, Humphrey's executor and so on. I think Humphrey's executor would have gotten overturned whoever was president, because overturning Humphrey's executor has been a core commitment of, and so it doesn't matter if it had been, if the correct case had come up at the time of Obama, the cases were going in that direction. And now the cases that come out of Trump 2.0, those are like they've been coming up through the shadow docket, but eventually they're going to be coming up in the ordinary course. But many of the most controversial things like birthright citizenship and tariffs and state commandeering and so on, we just haven't seen yet.
Well, let me give you an example of how I think your theory is not correct, which is that, and let's talk about a specific doctrine of law, the major questions doctrine. This is a doctrine that was invented by Supreme Court standards 5 minutes ago. It was invented under the Biden administration to invalidate environmental regulations. John Roberts wrote several opinions that say there are certain decisions that are so important, Congress has to do it. Administrative agencies can't do it as interpreting the law, because the major questions have to be determined by Congress, not by the executive agencies. This is a doctrine that was invented just to invalidate democratic priorities, as far as I am concerned. And I think that contributes to people like me having somewhat cynical approach to how the supposed doctrines that the Republican justices adhere to, because this major questions doctrine only arose when Democrats were in office.
You wanted my my response to that?
Sure.
Yeah. Well, right. So I got to say at the get-go that I've never been a fan of the major questions doctrine, and I think one thing about the major questions doctrine is it's so vague, because what is a major question and so on. Like, I think that Kagan has exactly right that the major questions doctrine is kind of get out of textualism free card. So with that as introduction, I think that there's a lot. There's a lot of it's been happening historically all the time, political judging. And by political judging, what I mean is not that the judges see themselves as operatives for the party, but it's just everyone's natural tendency. When you see a case, you kind of know in your heart how you wish it came out, and then you interpret the law in that way. Like, you say, oh yes, clearly the stuff that I don't like, oh yeah, it's got to be arbitrary and capricious. And then you're more inclined to strike it down. So for decades in administrative law cases, it tends to be that Republican appointees are more likely to uphold the administrative initiatives of Republican presidents and vice versa. So I see that as just an extension of the ordinary tendency in judging, which is that whenever you have a vague doctrine that allows people to say whether something makes sense, they are just going to tend to interpret the law in a way that naturally tends to align with what they want anyway. That's not specific to Trump. That's specific to kind of human nature as applied to judging, and like that's been going on for many decades before Trump.
Franita, you mentioned textualism, or the theory that the words mean what they meant in 1787. And so I want to turn to a bottom line question here. Despite the deference the court has shown so far to most executive actions, are there red lines that they would not permit the president to cross? For example, the repudiation of birthright citizenship, which to most observers appears to be clearly codified in very explicit terms in the 14th Amendment, or executive orders attempting to assert federal control over elections, which the Constitution explicitly reserves to the states.
So it's so funny. So I'm writing this book, right? And the book is about congressional power over elections. So the framing of the Constitution explicitly leaving this to the states, I would have resisted, like last year. I would have resisted that. I want to point out my own hypocrisy, right? Like, but one of the things that's very striking about this conversation is that we talk about things in terms of clear lines, right? So the 14th Amendment and the Civil Rights Act of 1866 guarantees this idea of birthright citizenship. Born here, subject to the jurisdiction, you are a citizen. One of the things about, to borrow Sasha's term, political judging, is that I don't treat anything as certain, right? I've always acted as if the justices, even lower court judges, are political to some extent. I think the problem that we have with the court is that people feel like the court is partisan, which in my mind is different from being political, right? The court is a political actor like any other political actor. In fact, what I teach my students when I teach Marbury is that it is the most badass political power grab in the history of the court, right? Because the court basically says, like, look, we are the ones who determine, we decide. And they do it without an army. They do it without any money, right? But they give themselves this power and everyone just kind of falls in line, right? So it's like this huge, just kind of gangster thing in my mind. But my point is, we can't talk about anything as certain as long as people are people. And the justices have always been political to some extent. So keep in mind, birthright citizenship, if it was so certain, it would be 9-0. Who thinks that decision will be 9-0, right? It'll probably be 5-4, maybe 6-3. Like there's nothing today, and not tariffs, not any issue that we're talking about that's going to be a 9-0 decision. So it's very difficult to talk about anything as a point of clarity. And I think that's just a function of our politics. The more polarized we are, the less we agree on even basic facts. And I think you see that in the way these cases are playing out.
Sasha, you seem to think there are some red lines, right?
I want to say yes, but I'm going to say something which will make Franita and Jeff happy.
I'm already happy.
Okay, well, that's good.
I
So
love it here.
I don't need to help.
So I'm
I
having
don't
a
need to
great
help you
time.
out, I suppose. But the thing is, so like I tend to agree that, for example, birthright citizenship should be a very clear win. I mean, you still have to decide what is the original meaning of the term subject to the jurisdiction thereof. And so there are all these arguments about what jurisdiction meant in 1868. So there are arguments, but I mean, I still think that the conventional wisdom, everyone born here, subject to the jurisdiction, because we are able to enforce our law against you unless you're the child of a diplomat or, particular special status for Indians or something. But basically, I think that should be a clear win. And I think that federal control over state elections, that also should be a clear win. But, I really felt that on the question, Trump v. Anderson, on the question of whether Colorado should be able to exclude Trump from the ballot because of his support for insurrection, as a matter of, Section 3, was it, of the 14th Amendment? Yeah. That was a 9-0 case. I feel it should have been 9-0 the other way, because I think that control over federal elections is clearly a state matter. And I think that if there were a dispute over whether the president was 35 or something like that, then I would think that would get litigated on a state-by-state level, and a state gets to control what's on its own ballot. So I sort of felt that as a matter of the original meaning and structure of the Constitution, Trump v. Anderson should have come out clearly 9-0 in favor of Colorado control over who gets to be on the Colorado ballot. But it was 9-0 the other direction. And I have to say that Colorado's position, even though correct, was kind of crazy. Like the idea that every state gets to say who gets to run in a presidential election. So I sort of understand why that happened. So I want to say that I'm going to predict that, yes, there are some red lines like that, but my level of confidence is not where I want it to be.
Can I just piggyback on that? Because I think the Trump versus Anderson example is a good one to prove that this isn't principled judging, because this really is about a chaos principle, particularly when it comes to federal elections. So there was another case, the faithless elector case, that was decided a couple years ago, where the Supreme Court, I think it was 8-1, where the Supreme Court basically said that states can fine or remove electors who don't vote in accordance with the state's popular vote. And they did so based on this idea that, around the founding, I'm being very intentional with my words here, there was this sense that, electors just kind of followed whatever the party wanted and whatever the popular vote was. But the reality is that at the founding, the expectations was that electors would exercise independent judging. And so they would exercise their own judgment about who the president should be and not follow a party. Remember, the original Constitution was a constitution free of parties, right? Parties came a little bit later, almost immediately, but still later. Right. And so, but the Supreme Court recognized that having a system where, it's kind of a free for all, where electors can choose whoever they want, it will lead to chaos. Trump versus Anderson is a very similar approach, right? That is not principle. That's not precedent. That's just, we don't want chaos. And it's just another example of how the court is just, these justices are applying their own judgment in some ways about what makes sense, as opposed to being guided by broader or greater institutional principles about how these cases should come out.
I think that's a great point about chaos and the fact that the justices don't want chaos. And I think that's another reason why they will vote to uphold birthright citizenship, because we have millions of people in this country who were born here. But if you get rid of birthright citizenship, their citizenship might be in question. And how would you litigate that? How would you try to take the citizenship away? How would you go to every maternity ward in America and decide who's, as babies arrive, who's a citizen and who's not? I think the immense practical chaos problems generated by a decision ending birthright citizenship will lead them, I don't know how many, but I think it will be 5 or more, to say that we're going to keep birthright citizenship the way it is. But the chaos principle that Franita mentioned is, I think, a very real one.
So I want to turn this over to the audience, but I want to ask each of you to briefly respond to the following. When federal district or appeals courts have ruled against presidential decisions, the president and members of his administration have tended to denounce the judges as liberals, out of control judicial activists, and some other less polite terms, even when in several cases the jurists in question were actually appointed by President Trump in his first term. I can't recall a time since the desegregation and criminal justice decisions of the 1950s and 1960s when so much of the judiciary was under such fierce partisan attack. If the president and the administration lose a major case in the courts, like birthright citizenship, something like the tariff question, any of those things, do you think he's likely to obey the court?
Well, I'll answer. I think he will. I think the Supreme Court rules against him. I don't even think he wants really to get rid of birthright citizenship. I don't think he wants the chaos that will result. He wants to be advocating against birthright citizenship, but I don't think it's a particular priority with the way many of the other issues before the Supreme Court really are genuine priorities. If I can just say about this issue of criticism. This is one area where I wouldn't say sympathetic to Trump exactly, but I don't think that judges should somehow be immune from criticism. Sure, he speaks caustically, but I don't have a problem with that. Obviously I am concerned about the violence potential, and there has been violence against judges. And obviously that's something we have to take very seriously. But the idea that the president's, if you remember when Barack Obama in a State of the Union address said he criticized the Citizens United decision, and Justice Alito shook his head, and people said, "Oh, it's so terrible that he criticized the Supreme Court." I don't think that should be off limits for Barack Obama or Donald Trump, as long as it doesn't provoke violence.
What if he doesn't obey a major decision?
Yeah, I don't want to see that world. But I do agree with Jeff that I think he is going to ultimately obey. And I think this is part of the weird dynamics of Donald Trump. I think it really helps that Donald Trump, I think, doesn't really believe anything. That if you had someone who was, like very, very hardcore ideological, and then, it might be, yes, I want Orbanism all the way. And then it's really important to maintain presidential control over the court and, stop obeying and have a political movement that delegitimizes the court and so on. I think from Trump's perspective, it's fine to take a loss because then you can keep railing against the court and you can score political points, and that's fine. I would be concerned if there are some other people of that movement who were president. So it could be that let's suppose that Trump weren't around and we had President Vance. On the one hand, things might be worse from an ideological perspective. On the other hand, we might find that he's as much of an opportunist as Trump, and that plus Vance does not have sort of the built-in very personal popular support, which might be a saving grace. But I think that from the perspective of just Donald Trump, the person, I think he's perfectly happy to just keep railing, but then ultimately obey the decisions.
Franita, last word, and then we're going to turn to the audience.
So I guess I'll engage in a little textualism myself. Define obey. I'm not sure. I wish I had the confidence of my co-panelists. I'm actually not sure. Because you can imagine a situation where in theory there's compliance, but on the ground there's non-compliance, right? If someone has citizenship issues that are somewhat questionable, and they leave the country, and then the State Department gets involved or something, or TSA at the airport, or so what does obey mean? And this is actually goes back to our discussion about the shadow docket. You have executive orders that fundamentally change the status quo, and then you have decisions being made on the shadow docket that basically freeze it in place, this new status quo in place, but it ultimately destroys a lot of the programs that were withheld funding, right? So even if they ultimately win in the end, how do you come back from that? So a lot of things can happen on the ground, and in the interim that ultimately render the word obey meaningless, right? He can go on TV and say, we'll obey, but what does it mean for the various departments that do things that touch on our citizenship?
Okay, let's turn to the audience. Someone has a microphone. Do we have a microphone for? Yeah, right up here.
Thank you. Thank you for the discussion. I wanted to return to Bob's first question about the Comey indictment and focus on the grand jury. The grand jury didn't indict on the third count, and I think they only indicted on the first two counts by a bare majority of 1 or 2. So my question is, does this show, can the grand jury ever act as a legitimate check on prosecutorial discretion? And my second related question is, if we ever have a Congress that would ever take a look at judicial reforms, I know a lot of people talked about Supreme Court reforms, are there any reforms to the grand jury process that could allow the grand jury to act as more of a check? Thank you.
Well, I was in AUSA back in the day, and so I used to practice in front of grand juries, and I was astonished to see that a grand jury voted down this count because they tend to be very, very passive. And there are several examples in the District of Columbia where they have voted down entire indictments, not just individual counts. I would say don't get your hopes up as a thinking about the grand jury as a meaningful check at a systemic level. I mean, the structure of grand juries is such that, as I'm sure most of you know, the prosecutors are the only people who appear in front of the grand jury. In federal court, hearsay is admissible, so you usually have just one witness summing up all the evidence, usually some sort of law enforcement agent, and you only need a majority of the grand jurors to vote for an indictment to get an indictment. So all of that makes this a very low bar through which these federal cases can pass. If I am interested in criminal justice reform, and which is a great subject, I would pick another area besides grand jury reform because I just don't think it's ever going to be significant.
Okay, another question over here, there, and then there.
I have a question for Jeff. In July, President Trump threatened to remove Jerome Powell from the Federal Reserve if he doesn't lower the interest rate. Now we are seeing the Federal Reserve is lowering the interest rate. Do you think Trump's threat worked? Are you concerned about the integrity and independence of Federal Reserve? Thank you.
This is such an interesting area because structurally, the Federal Reserve is very similar to the National Labor Relations Board, the Federal Trade Commission, Securities and Exchange Commission, where the Humphreys executor applies. And in one of these shadow docket decisions a few months ago, in the 2 or 3 paragraphs, they said, well, we think Humphreys executor in effect is terrible for everyone except the Federal Reserve. Now, the real reason they seem to have said that is because so much of the economy and so much of the expectations of bankers and the people who are, calling the shots in our economy rely on the independence of the Federal Reserve. So I think, to adopt Franita's chaos principle, they are going to make an exception for the Federal Reserve, even though if you were applying logic and consistency, they wouldn't apply an exception. But I think they really are going to preserve the independence of the Federal Reserve because of the practical aspects, not because of the legal issues.
Well, I'm going to partly agree. I think they probably are going to retain a carve out that would encompass the Federal Reserve. I don't think it's just going to be a Federal Reserve only carve out. The thing is, the unitary executive, like the whole idea of why Humphrey's executor is wrong, the idea that the president should be able to remove any officer of the United States at will, that theory is kind of made up. So I don't think it really has a lot of original backing. But given that it is made up, what would be a sensible doctrine to make up? And I think that the internal logic of unitary executive is that the president is in charge of the executive branch, and so he should have, and he's, the Article 2, the first words say that the executive power is vested in a president, and so he is the executive branch. And so the idea of looking to how much executive power a particular official wields, I think, is relevant. And if you're going to say that a central bank actually wields a kind of power that can't be characterized as executive, and it's very different than prosecutors, or it's very different than, FDA, EPA, whatever, administrators, I think that, it's still made up, but I think it's an entirely plausible distinction, and it's kind of consistent with the internal logic of unitary executive. It's not consistent with it's not consistent with the grandest visions of presidential control over everything, but I think it is consistent with a kind of sensible unitary executive.
This is what you learn in law school, which is to make distinctions when none actually exist, which is what you just did.
Franita, do you agree with that?
Which part?
that you make up distinctions when none exist because of your chaos.
That's definitely what they teach us.
So, not to. But there is something to this idea. I actually don't disagree with any of this, in the sense that I do think that there is a framework where they look more at the function of the official as opposed to sort of an absolute rule of endorsing the unitary executive, right? Like, is the function more legislative or judicial versus executive? So I don't necessarily think that. So in a world of made up things, I do think that that's a real distinction that the court would hang its hat on. So that's a good compromise.
Okay, I'm right here, I promise. And we'll do one more here and then one over here.
Thank you. Hello, my name is Kana Kai, and I'm a freshman here studying legal studies. I really enjoyed the panel, and I especially enjoyed the disagreements. So I have a two-part question. First, who is your favorite Supreme Court justice? Could be dead or alive, could be on this court or not on this court. And the second part is, what do you think about Justice Scalia's judicial philosophy?
Ooh, I got good answers to both. I'll go first, since I just invited myself to go first. My favorite justice is Robert Jackson, who served on the court in the 40s and 50s. He took time off to be one of the Nuremberg war crimes prosecutors, and he was the best writer, the best prose stylist ever to serve on the Supreme Court. And I direct your attention to the case of Barnett versus West Virginia, which is a case decided in the middle of World War II, very significantly, about whether students could be disciplined for refusing to salute the flag at the beginning of the class day. And it is the most beautiful expression of why we tolerate dissent in this country. And so he's my favorite justice. Let me tell you, when I was writing my book, The Nine, I went to an appearance Justice Scalia did at a synagogue in New York, and someone asked him a very interesting question, I thought. They said, Justice Scalia, what's the difference between your judicial approach and Justice Thomas's? Because you're both originalists. And he sort of fenced around for a while, and he said, look, I'm an originalist, but I'm not a nut. And I thought that was a good distinction between Justice Scalia's approach and Justice Thomas's. And that's what I think of his approach.
Sasha, you going to pick Alito or Sandra Day O'Connor?
Yeah, well, with all due respect to my actual bosses, but I think rather than comb through Supreme Court history, I'm just going to say, of the justices who are on the court right now, I think I'm gonna pick a pair, and I'm going to say Neil Gorsuch and Elena Kagan. And so they are often treated as being on opposite sides, but I've known both of them for over 20 years. And Neil Gorsuch I knew when he was a Supreme Court clerk himself, and Elena Kagan was my administrative law professor. And I think both of them are really serious and do kind of very interesting work, and often will vote contrary to where you might think naively, just from a political perspective, they might come down. Elena Kagan, Jeff is laughing.
I was
Ela-
with you until that last comment.
Anyway, I'm gonna say those, and then as for Justice Scalia, I think there's one thing that Justice Scalia was really important for was making the concepts of textualism and originalism kind of popular and mainstream, and they're so popular and mainstream that a lot of people are calling themselves originalists these days, and I think that can hide just how much variation there is in terms of what it means to be originalist. And I think that most of the people doing originalism, let's say on the court, I think are doing it badly, and if I were doing originalism, I would do it very differently. And so I think that in a sense Scalia was so successful at what he was trying to do, and that the philosophy has become a victim of its own success.
Franita?
So I'm going to pick someone who is dead, in part because Dred Scott was decided in the 21st year of Justice Taney's uh, tenure on the Supreme Court, and so there's still a lot of time for the people on the court now to mess up. So I'm going to go with Justice Brennan, who I think sort of recognized in a way that I think at least more explicitly than his co-justices, the political nature of the court. He was as much a politician as he was a jurist, and quite a brilliant one. In terms of Justice Scalia was a very brilliant person, and he, to me, is the embodiment of the fact that it takes more than brilliance to be on the Supreme Court, or at least it should.
Quick question over here, because we're kind of out of time.
Hi. Reviewing the past, um, the past rulings of the Supreme Court over the past year, and using only the Constitution as a measuring stick in the most liberal or the most conservative interpretation of that document, how would you say that the rulings coming out, do they seem to follow that, or are they going and kind of using that as an inconvenience and basing their decisions on their own ideology, and that would include the shadow docket?
I would say, I think it's a little unfair to the justices to say that, well, you just look at the Constitution and you can figure out how these cases come out. I mean, the Constitution is written at such a level of generality, as it should be, that it's there's a lot to know that you have to look at the precedents and look at the policy issues. So it's not just the words of the Constitution. And also, it's important to remember that the Constitution, except for the more recent amendments, was written in the 18th century. Asking what James Madison thought about wiretapping or bugging buildings or the regulation of cable television and the internet is just, I think, a fruitless exercise, though justices say that they're doing that. So I don't think that it is the text of the Constitution that they are violating. I think they are violating and I think they are violating the understandings and precedents of the Constitution as it has been developed over many decades.
Franita?
Actually, I don't disagree with that at all. I think it's more so a question of constitutional norms, as opposed to constitutional text, because and it goes back to our earlier conversation about the questions that the justices got at their confirmation hearings, right? A lot of it dealt with precedent, in part because we often confuse the constitutional text with how the Constitution is interpreted, and we treat the interpretations as if they are binding and definitive. But we also formulate our norms around those interpretations. And so it feels like in this moment, those norms are being violated in a way that we're not used to.
Sasha?
Yeah, I think we were talking about the chaos principle earlier. I think no one really takes their jurisprudential philosophy super seriously, even if they claim that they do. And like for example, my boss, Justice O'Connor, she was really her view was kind of let's just see how we can make the law work. And it was kind of a practical sense of what made sense. And even if you and she was never the sort of person who would say, this is my ideology and I'm sticking to it. On the other hand, take somebody like Justice Thomas, who really does make a big deal of saying this is my ideology. But if you look at First Amendment doctrine, and I think Justice Thomas has been very good on First Amendment, but the First Amendment doctrine does not have a single originalist thing in it, and it's all kind of a made-up, like on the basis of precedents, mostly from the last 50, 60 years. And that's great. That's actually one of my favorite parts of the Constitution. I just finished litigating a case where I was representing strip clubs, and we were challenging a Georgia tax on strip clubs. And I lost in the Georgia Supreme Court, and I filed my cert petition where I argued within doctrine. And I wanted to say in a little footnote, I know you guys sometimes say this is a really non-originalist area of the law. Let's just kind of rethink everything from the ground up based on original understandings. If you do that with the First Amendment, please don't do that in this case, because I will lose so badly if you do it. Do it in the next case. And they denied cert, so that case will not be decided. But what I'm saying is that Justice Thomas joins and even writes First Amendment cases that have nothing to do with original understanding, and so I think that in the end, it's all a matter of the justices are thinking what makes sense in the context, how much weight do you want to give to precedent, even when it overcomes, even when it contradicts what you might have thought from initial principles. And I think everyone is, in my view, is in kind of good faith trying to do the same enterprise.
What a great discussion this was. Thanks to our panelists. I mean, this was really fabulous. Thanks to our audience, whether you're here or remote, or we'll hear this later, as I said, on our podcast. Join us virtually for our next event on October 29th. Latino voters, where do they go from here? Where my co-director, Mike Murphy, will be in conversation with Mike Madrid, Chuck Roca, and Helen Torres on the ever-evolving Latino electorate. Thanks, and have a great week.